Hello, and welcome to Galen Data's Medical Device Connectivity Innovation Webinar Series. Our webinar today is broadcast live from the frozen tundra of Houston, Texas. We hope everyone joining us today is warm, safe, and healthy. My name is Keith Drake. I'm the Vice President of Business Development for Galen Data. Our topic today is very exciting, the importance of medical device intellectual property. First, we'll lay a foundation, how patents relate to medical devices, and then we'll explore several practical do's and don'ts to maximize the business value of your innovative technology. And of course, we'll take your questions. Today's guidance and insight will be shared by our guest presenter, patent attorney Timothy Scott. Timothy has served as patent counsel of cardiac surgery for Livanova PLC and assistant general counsel intellectual property for Cyberonics. He has helped to harvest and secure the intellectual property for hundreds of medical device patents. He earned a Juris Doctor from Syracuse University College of Law. He earned the MBA from the University of Houston, Victoria, and he also has a Bachelor of Science in Chemical Engineering from Louisiana State University. Tim, welcome. Thank you for joining us.
Good to be here. Thanks, Keith.
Let me briefly go over some of our webinar logistics. You can submit your questions for our Q&A session at the end of our webinar at any time in the questions window in your GoToWebinar console. There are some information handouts that are available for download right now. We encourage you to do that. We're going to take a couple polls during our webinar to learn a little bit more about our audience. And then finally, a recording of this webinar will be provided in a follow-up email. I'd be remiss if I didn't remind everybody about the Galen Cloud. It is a secure, compliant, and turnkey cloud connectivity platform purpose-built for medical devices. It's compatible with all cloud infrastructures, AWS, Azure, etc. It is ISO 13485 certified, FDA, HIPAA, GDPR, and CCPA compliant. In a nutshell, it's a highly configurable interface for data access, display, levels of access, alerts, and more. We're going to cover a lot of ground today. I'm really excited about our presentation with Timothy Scott. First, we'll lay some groundwork to define what is intellectual property, and specifically as it relates to medical devices, and then dive into the value of patents, the business value to, I think, a majority of our audience today. Then we'll get into some of the nuts and bolts, invention harvesting, patent prosecution. There's a lot more to it that I've learned from you, Tim, over the past couple of weeks that we've been working on this webinar that I think will be enlightening for our audience. We'll get into patentability standards, what is patentable, what is not, and that'll take us into the final very practical and actionable information, intellectual property do's and don'ts. Our hope is that by the end of this webinar and Q&A session, that you'll have some actionable information to increase the value of your business. So we'll go ahead and run our first poll. I'll ask our producer to launch that. Please let us know what type of organization you represent. Do you represent a medical device manufacturer? Perhaps a company who is developing or offering to the marketplace software as a medical device? Do you represent a device design development company? Perhaps a quality or regulatory organization? And if none of those apply, please choose other. So again, the choices are medical device manufacturer, software as a medical device company, device design development company, quality or regulatory organization, or other. The poll is in your GoToWebinar console. I see a lot of responses are coming in. We appreciate that. Give everybody just about 5 more seconds to make your final answer. And we'll go ahead and close out the poll. So with that, Tim, I'd like to turn it over to you. We've got a lot of ground to cover today. You've got a lot of experience. Where do we begin our discussion?
Well, the first thing I would like to do is reiterate your point that I hope everyone is safe and warm. This tropical storm Uri is really throwing a monkey wrench into a lot of things, including here in the Houston area. But we certainly hope everybody is safe and warm. And and out of danger. I want to start just talking a little bit about what is intellectual property. Essentially, it's the intangible creations of the mind that's most important here. You know, unlike a record or a CD or any tangible medium, it's not the tangible part of it that can wear out that we're protecting. It's the intangible thing, the thing that can be used over and over and over by anybody. Yeah, there may be a tangible implementation of it, but we're talking about the intangible aspect, really the idea of what it is that you're doing here. There are basically four big types. There are some exotic things like semiconductor chip designs and so forth that have some very specialized statutes. But I'm just going to identify four big ones, and then we'll focus mainly on patents for the rest of the talk. The first is patents. They protect novel inventions, a technical idea. They give you the right to prevent other people from infringing it, from using your idea from 20 years from the date of the filing date. That used to be different. It used to be dated from the issue date. In 1995, we made a change to go for 20 years from the filing date, and that could be an earlier date if you're filing what's called a continuation or a continuation in part. Then you have trademarks. We're all familiar with those. They can be words, they can be images or designs, or they can be both of those. And those can last forever as long as you're using them. You can't, if you go out of business and you stop using your trademark, it's fair game to use the same mark in the same area if they want to, but you have to be using it in conjunction with goods and services. And then of course there's copyrights. That can get very, very difficult depending upon when the term can get very difficult depending upon when it was created and when it was published. It gets very hard because there have been so many implementations of the copyright law. It can be very difficult. You know, if something was published in 1940, created in 1944, but not published until 1954, you really need a lookup table. Just to give you you know, one or two ideas, for something created in the U.S. after 2002 by an individual author, let's say you wrote a book, the term would be 70 years after the death of the author. Or if it's a publication by a corporation, you know, let's say a user's manual for a medical device, it would be the earlier of 95 years from publication or 120 years from creation. Now, you can always, a lot of us wonder, well, why would you wait 25 years to publish it? Why these different terms? I don't want to pursue that. That's a whole, we could talk for an hour on just that. And lastly, there are trade secrets. Those can be very important. And sometimes you have to choose between filing a patent on something and getting a trade secret. And we'll talk a little bit more about that. But a trade secret can really protect anything. It's not limited to technical ideas like patents. It could be financial information, technical information, economic information. It could be tangible or intangible. But the main point is you have to keep it secret. You have to take steps to keep it secret. And then you can get damages if somebody violates that. Let's go to the next slide. Okay, the main thing I want to talk about today is patent rights, and mainly for startups. That's what I typically do these days. I spent the first part of my career as a litigator, so I've seen almost every way you can mess up a patent. Since after about 7 years, the last 20 years, I've been doing corporate work. First for 2 medical device companies, and then the last 4 years really just helping startup companies. Patent rights are not an affirmative right to allow you to do what's in your patent. You could actually be blocked by another patent, so you need to make sure that you have what's called a freedom to operate. We'll also discuss that, but it's a negative right. It allows you to prevent other people from making, using, selling, or even offering to sell what it is that you have patented. You know, the main value, of course, is it can deter people from entering your market if you're the person selling the patented item or the patented, practicing the patented method. And you can get monetary damages. You can also get injunctive relief. You can get a court to say to the infringer, you have to stop infringing it. You can't make this device, you can't sell this device, you can't offer to sell this device. So it's a very potent remedy. There's some other specific types of remedies in the International Trade Commission. I used to do litigation there. you don't get monetary damages, but it's typically used in the international context. If you have an infringer, say in China, that's very hard to get jurisdiction over, you can sue their distributors in the United States and them sort of in absentia, and you can get an order, if you prevail, to the Customs Department that prevents their devices from even entering the United States. Another big important, especially in the startup context, another important reason for getting patents is to justify investments in technology. The average cost of a new drug is somewhere from, on the low end, maybe a couple of $100 million to the high end of more than $1 billion. And you're always one experiment away from having to throw all of that away if something goes wrong. So you have to justify that, and patent rights are one way to do that. If you know, well, we've got 10 or 15 or 20 years that we can prevent generic manufacturers from jumping in, we have enough time to recoup those development costs plus some. So it's really important to have those rights, even in mature industries, and it's certainly almost critical to have it for a startup. Another one is attracting investors. For startups, that is another very important point. You might have just a provisional application. Better yet, you might want to try to get a fully issued patent. And there are ways to do that, to accelerate that process. If you're a startup, you can file what's called a petition for expedited or prioritized examination, sometimes called a track 1 request. You have to pay $2,000 to do it, or maybe a little bit more if you're a micro entity, a little bit less if you're a micro entity rather. But basically, your application goes to the head of the line. So you're looking at an office action in a few months, weeks to months rather than years. And you can often, in fact, I just did it last year. I filed an application the last day of February, and it was issued in December. So you can do that and potentially get an issued patent very quickly to attract investors. Even if you don't use the patent, or let's say you have a patent that's usable in multiple fields, you might say, well, we're only going to use it in one particular field, but let's say medical devices, but it may have non-medical uses. You could potentially out-license those to someone for these non-medical uses and get a royalty stream from that. So you always want to try to expand your patents as much as you can to cover as much as you can. On the flip side of that, maybe somebody has some technology that you need, and you can in-license that or cross-license. Maybe they have something you need, and you have something that they need, and you can say, well, we'll each give you the other rights to those technologies, and we'll avoid a lawsuit, and then we'll all be so much the better. And it can also impose significant regulatory burden for medical devices, particularly if you're talking about a Class 3 medical device, but even a Class 2. And in some cases, even Class 1, you can impose a regulatory hurdle to prevent people from jumping in too soon. Let's go to the next slide. So what do IP lawyers do, people like me? There's a bunch of different functions. I'm going to go through these very, very quickly. First is invention harvesting, and I'm going to spend some time on that. That's one of the areas where startup companies, I think, and really even mature companies fail the most, and even medium-sized companies. When I've joined two medium-sized med device companies, that's the thing I focused on the most, is making sure you're not leaving the best ideas, just not even unpatented, but unconsidered. You don't always patent something, but you want to make your decision not to patent it a deliberate one, not just one through ignorance because you never harvested the idea. Then once you harvest those ideas and you've decided to file patents, there's the process of patent prosecution, and that's the second point here. That's the back and forth with the U.S. Patent Office or the European Patent Office or wherever you happen to be. They may reject the claims, you can respond, you can amend them, or you can argue with them. But the process of going from a filed application to an issued patent is called patent prosecution. And then there's product clearances or freedom to operate, some commonly referred to as FTO. And we'll talk a little bit about that. And that's making sure that you're not infringing somebody else's rights. And then finally, you can analyze the portfolios of your competitors or somebody that you know has technology you may be interested in. You may look at what they have before you approach them and go with a concrete proposal. Hey, we'll offer you this, or we'll license it for this much, or we want these 3 patents, or just this one, or we want a whole field of use. So that's an area that can frequently be very helpful. IP education and training. Let's go back one quick, Keith. IP education and training. This seminar is an example of that, but you can have other policies in place, drafting of policies. Very quickly, negotiating agreements, license agreements, managing that. Once you have those agreements, you manage the external relationships with the licensees, licensors, and then finally you deal with copyrights, trademarks, trade secrets, and the other things. So the next slide talks about invention harvesting, and I want to really emphasize that this is the area for startups that you really need to focus on. I'm amazed, continually amazed at how often very valuable patent rights, millions of dollars, are just lost because you either don't harvest them or you don't harvest everything that you can get. The first thing to do is you try to identify, so what's the standard of patentability? We're going to go through that, but when you're thinking about it in a very practical way, if you're the engineer or the scientist, try to identify areas where you had to think a little bit out of the box. It's something that it wasn't just B-flat engineering, and that's a big problem. A lot of engineers or scientists think, well, I'm just doing my job. Well, that's not the standard of patentability. But anything that you thought, this is just a little bit different, maybe this is particularly valuable. It could be, it's a new problem. You're doing something so new that nobody has seen the particular problem, and you found the only solution you're aware of. Or maybe it's an old problem, but in your context, because you went down a different path, it forced you into a new solution that's different from everything that's out there. Or it may be just in the solution may just be in your context. You may be applying something in a field that's really fairly far away. Something for whatever reason may have said, I can borrow this in a completely different area that nobody would have ever thought to use it, and it may be related to the fact that you're seeing things, you're in some new regime because of the problem that you're trying to address. Typically, it results in an improvement. Now, technically, that's not a requirement of patent laws. It doesn't have to be quote an improvement; just has to be different. But if you're going to file a patent on it, there's got to be usually some commercial reason to do so, or you might consider keeping it a trade secret. You also want to try to write it down, and I don't mean take a pen and pencil. You can do it on a word processor, but you want to try to go through the process of explaining it, because that will force you to identify sort of the outer boundaries of it. You may have a core idea, but in thinking through it and saying, okay, here's the problem, you may see some outer or special circumstances or additional aspects that you need to discuss that may be the subject of either additional claims or at least dependent claims, some particular aspects, particular sub-solution, if you will, that you can do it 2 or 3 different ways, and you want to try to say what's in and what's out, what's part of the invention and what's not. And you need a written disclosure, because when you go to a patent lawyer, that's the thing they're going to want to use to guide them in drafting the claims and the patent application. And then also, as part of the harvesting process, you want that written disclosure, because you need that to go through the formal process of winnowing these things down, trying to find what do you want to file on and what do you not want to file patent applications on. That can have the form of a patent review committee. Typically, that's going to involve not just technical people, but marketing, sales, finance people. You want to get a big perspective, because sometimes it's not the things that the technical people think are very small or a minor issue. That's the thing that actually has the most commercial value. And you want to make sure that when you draft the patent claims, that you capture those commercially valuable aspects. You might capture the technical values as well, technically new features as well, but you want to ultimately, patents are not plaques to hang on a wall, they're business assets. And I always have tried to think of myself as, yeah, I've got a law degree and a chemical engineering degree, but I always remind myself, look, these are business assets. We're all in this thing to make money, to make people's lives better through some product or service. So these are business assets, and you want to harvest those. So patent prosecution, I mentioned already that that's the process going back and forth with the patent office. It involves going from that invention disclosure to drafting a new application with claims. You also, in the United States at least, you have to disclose to the patent office all of the so-called prior art that you're aware of. You can't hide things. If you know something is very close to you, you have to disclose that to the patent office and say, hey, we think we're still patentable, but here's some things you should be aware of. That's called an information disclosure statement, commonly referred to as an IDS. And then the patent office will give you a written statement saying it's either allowable or it's not, and if it's not, why not? And then you can respond to that. So that's called an office action, and then you've got a certain time period to respond. You can amend the claims. You can say, no, you're just wrong. And there's usually a back and forth process. You can also interview the examiner. And I am a firm believer in interviewing the examiner, because you can show him you're not seeking more than you're entitled to. That can gain you a lot of credibility with the patent office, and I've found that that's a very valuable tool. For foreign rights, that patent review committee needs to decide, hey, are there markets that are critical to us? Or there manufacturing sites that we want to potentially cover and get patent rights in to prevent somebody from infringing? And then also, you need to prune your portfolio from time to time. If you have something you're not really practicing, you don't see an opportunity to license it, stop paying maintenance fees on it. Outside the U.S., you have to pay maintenance fees every year, generally. In the U.S., we pay them at 4 years, 8 years, and 12 years from the issue date, and that is an increasing fee. So if you have this, you don't just go get patents all over the world. You try to find them in key jurisdictions, because the cost of that keeps going up. And every time you say, yeah, I want it in France or Germany or Sweden or wherever, you're going to have to pay annuities every year, and the annuities increase because presumably you're getting more value out of it as the product gets online, the product matures, and you're selling more of it. So the annuities keep going up every year. Next slide. Product clearance, we discussed that. This is the process of trying to identify other people's patents that you're looking for, that you might infringe. You need the first step in that is identify what your own product is, because until you know that, and know that in some level of granularity, you can't really search it properly. Now, typically that process is going to go from the conception phase of whatever product you're doing all the way until marketing. You need to keep doing that, keep updating it, because there could be patents that you don't know about, because patents are secret until 18 months after they're filed. So you need to keep searching that, keep doing, so to characterize your product as much as you can, down to as much level of detail as you can, and then you go do searching. And you may need to do searching in 3 or 4 or 5 different areas, depending upon all the features. And what that gives you is, in many instances, you can find up front, yeah, there's art that's real close to us, but we can actually avoid these patents by designing around it, by taking a different path, because we're doing it slightly different from them. We don't have to use their technology. We can avoid that by doing a design around. In some instances, even if it's a real problem for you, in some instances you can say, boy, and I've done this myself many times. I've seen patents that I can name 5 patents that should invalidate that right off the bat. Why was this patent allowed? Well, if it's that important and it's a critical market, you can go to an outside law firm and potentially get a written opinion saying, well, we think this patent is invalid. Now that's going to be really expensive. It can range from $15,000 to $30,000, $40,000. But it avoids treble damages, because if you willfully infringe something, if you knew about it, you infringed it anyway, you're subject to treble damages. So you may still lose, but with a written opinion, that can give you some protection against treble damages. The law on written opinions goes back and forth. Sometimes the court decisions say, yeah, they're absolutely required. Sometimes they're not. So before you go do that, check with a patent lawyer. Let's go to the next slide. So what's the standards of patentability? Well, there is a constitutional basis for it. In Article 1, Section 8, Clause 8, it says Section 8 is a list of congressional powers, and Section 8, Clause 8 says Congress shall have power. Point 8 is to promote the progress of science and the useful arts by securing for limited times, they can't be perpetual, to authors and inventors the exclusive right to their respective writings and discoveries. So you can see right away, it's not designed to be a lottery. It's designed to raise everybody's standard of living. It's designed to get more technology out there over time. So you give an exclusive period, and then over time, as we all know, the generics come in, right? So the type of price of the drug, device, whatever, keeps going down, and ultimately we can get new technology, new money invested for new technology, and our standard of living and new products and services get out there. So that's the constitutional basis. But the statutory basis, that the Constitution says you can have a patent law. It doesn't say you have to. So we've had one since 1791, and the most recent versions basically in 1952, and there have been lots of amendments, but there are basically three requirements. It has to be novel, useful, and non-obvious, and that's called utility or usefulness is Section 101, novelty or newness is 102, and non-obvious is 103. Well, Section 101 basically says, okay, here's 4 categories of subject matters you can get a patent for. It's got to be new and useful, but it can be a process, a machine, a manufacturer, a composition of matter, or this big gloss on all of those, any new and useful improvement of those things. So that's utility. And I should mention, utility is what the Supreme Court has recently begun to restrict the scope of our ability to get rights for software. I think they've messed it up, but that's you have to. Utility used to be pretty easy. Now it's a little harder for software-based patents. The next section is novelty. That's Section 102, and basically it says there's not. The examiner is saying, if he rejects you for novelty, he's saying, look, I found one thing. Whether it's a printed publication, it may be an actual product that's out there, it could be an issued patent, or the worst case is your own actions prevented you from getting a patent. You demonstrated it, you used it publicly, you offered it for sale, or you sold one before you more than a year before you went to the patent office. So that's really Section 102A, 1, and then it can also be a third party or something that happened later. It's really the first public disclosure that the 1-year clock starts. Let's go to the next slide, which really talks about, I believe, that 1-year grace period. So in the United States, and the next slide will show limits on that, you basically have a year. You can make a public disclosure, and then you have, it starts a 1-year clock, and you can go to the patent office and file something. But that's not the most advisable thing to do. The most advisable thing to do is to file something first, even if it's just a provisional patent application. So let's go ahead. I think this is fairly straightforward. I don't want to spend a lot of time on it. The most important thing is the 1-year grace period only applies to the United States and a handful of other countries. Japan gives you a period of a 1-year period. Canada, Australia, South Korea, but most countries don't. Europe does not. I don't think China does. So you know, if you disclose that, it's fatal. You can't get rights in those countries. So for that reason, these foreign restrictions, typically, if you're going to get international rights, that requirement, the lack of a 1-year grace period, really argues strongly that you should go ahead and file something in the United States. There's another way around that. And that is to have a confidentiality agreement. We'll talk about that in a minute, but let me say one more thing here. There are a lot of ways to get into trouble here, and you really have to watch what you're saying to third parties, particularly if you're a startup. Technical publications, even a just a discussion with somebody that discloses what's in the patent. Your best bet is to try to talk to people at a high level. Just say, well, here's the general area that it's in, and only disclose the details if you get them to sign a confidentiality agreement, or better practice, file a patent application. Then you can talk about whatever's in that application to them, because your date is already set, your priority is already set. Next slide. So the third standard is non-obviousness. When you're in the patent office, this is the standard that is most often used to reject you. There are many instances where your technology is new enough or different enough, the examiner can't find one single thing that is invalidating you. But he'll cobble together 2 or 3 different references to say, well, you're claiming A, B, and C. I see A and B in reference 1, and I see C in reference 2. Anybody could cobble those together and get your invention. Examiners are really great about hindsight recreation. That is, once they see your invention, they're really good at going and finding all the pieces of it and ramming it together. That's not the standard of patentability. It has to be obvious to a person of ordinary skill in the art. That's the biggest problem. Let's go to the next slide, because we'll discuss that in more detail. The biggest problem that most people, engineers, and companies have is they assume the standards of patentability are higher than they really are. The standard is what is obvious to a person of ordinary skill in the art. That is, was there one thing that had it? But if there's not, would a person of ordinary skill in the art, if you put all of that stuff before them, would they be able to arrive at your solution? Now, if you're a PhD scientist who's worked in this area, your technology area for 20 years, you're typically not a person of ordinary, but extraordinary skill in the art. So what you think is obvious is not obvious. The standards of patentability, I've found most engineers and scientists usually think is the real standard is, well, it's whatever I know plus a little bit. That ain't it, folks. And I've seen so many patents not get harvested and not get filed because of that. So that's the one thing. You really don't assume the standards of patentability are really higher than they are. There are a lot of common errors. You want to have, as I mentioned earlier, you want to have a harvesting process. It doesn't have to be formal, although the more formal it is, the better it are. But you don't want it to be an afterthought, because you, as we mentioned earlier, you're trying to justify an investment, whether it's to attract new capital or justify, even if you're a huge company and you got millions and billions of dollars, and you're going in a totally new area, you got to justify that investment. And you don't want to wait until you've done a lot of R&D and wasted a lot of time, and then find out, well, gee, we can't get any patent rights on this. You want to address that up front. So you want to start the process of harvesting and have it ongoing. Another big problem is that public disclosure that we talked about. That is, you talk to somebody without a confidentiality agreement, or you'll demonstrate it. You'll bring somebody into your office, even though it's in your offices. If they don't have any confidentiality obligations, that's a public disclosure. Just because it's behind closed doors, that's a public disclosure. Anything that is not subject to a confidentiality agreement and is not within your organization is a potential public disclosure. So that's a big problem that you need to be careful of. Thinking of the invention too narrowly. I always try to when I deal with inventors, I'll ask every question to try to say, well, could you apply it this way? Could you apply it that way? You want to try to think of it not just, hey, it's this little piece of this one product. Think of the product bigger. Hey, now that you have your solution, does that make other features possible? And you want to claim all of those things. So you may have an idea that's on one particular area of a big thing, like an engine or a car, but you can potentially claim the whole car, right? Having your feature on it. Or you can talk about the method that your device or machine performs. So a lot of times I'll try to get patent claims that are both to a device or thing and to a method. You don't want to think of the invention too narrowly. We've already mentioned, and I probably spent quite a bit of time on, no formal harvesting and review process. You want to capture everything, and you want to make sure that only your limited resources, and resources are always limited, are going to the most valuable things, that most valuable ideas. You can't patent everything, but you want to make sure you're getting the most value for your dollar. And then finally, no state-of-the-art review. It's very frustrating to get a patent and then find out later that there are other people in the same area. Next slide. Solutions, I think we sort of alluded to a lot of these. Make patent rights a very early priority, because I guarantee you, if you don't do this, you're going to find yourself needing to make a disclosure and then scrambling to get something filed. That's going to cause you problems in more than one area. One, is going to be a shortened process, and you're not going to capture the full range of it. And two, you run out of time in what you can file. You cannot, even if you have it, you may not be able to get everything in there before you need to make that in the patent office, before you need to make that public disclosure. So you want to file patents very early, maybe even before you incorporate, your entity. Sometimes you can do it with just a provisional application. The advantage of a provisional is this very inexpensive, couple $100, $300, $400 maybe, even for large entities. So you can do it very quickly, but it doesn't confer any rights. And more importantly, you're not free then to go talk any and all details. It's only what you disclose. That's another reason to do it early, because the more complete your invention submission to the patent office is, the more protected you are in terms of what you can disclose to other people. You need to view IP as a strategic asset. We've talked about that. Make sure you only disclose subject matter after filing it, or at least under a confidentiality agreement. Sometimes you can't do that. Sometimes people are unwilling. If that's the case, what you have to do is disclose it at a very high level. Don't go into details. Just say, look, is this broad idea something that you'll be interested in? You don't want to just make that public disclosure and then kill your rights for ex-US patents in most cases. Consider filing, 3 or 4 patents. If you to get to your solution for the whole system that you're designing, you had to file 3 or 4, figure out solutions to 3 or 4 technical ideas, file patents on all of them, and then file patents on the whole system. So you want to have families of patents. So if you think of a series of concentric circles, yeah, you've got what you thought was the core idea, but then you've got patents around that and around that and around that and around that. So it gets progressively harder, for a potential infringer to really practice something without a significant risk, to get to your so-called crown jewels, if you will. And then lastly, make sure you look at least a little bit into what your competitors have. Another reason for doing that is sometimes you can see, hey, because of the way we're thinking about this technology, there's a whole white space that's unpatented. There's an area that's just virgin territory. We can get in there and really have a lot of patents, not just on what we're going to do, but on what they might do in this area. And sometimes a rival technology is out there, and you might even file patent applications deliberately in the area. Just have a brainstorming session, try to say, here's where I think they're going to go. File something to cause them problems, to potentially give you something to horse trade with them. If they have some technology that's blocking you, you can at least do that cross license that we discussed earlier. So I think those are the main things. Are there any more slides, Keith? Those are the main things I wanted to cover. We're going very, very quickly.
Yeah, no, you've covered a lot of ground. It seems to be less of a legal matter and more of a business chess game for sure. It's not just the what, but the how and the when as well. All have to mesh together, and you really have to know what you're doing. You have to know what you're doing it with, but you have to know how to execute, prosecute, harvest on what you have.
Right.
Very good, very good. So we're going to roll along here so we can get to our Q&A session. I see questions are already coming in, some pretty good ones. We're going to challenge you here in a few minutes, Tim.
Okay.
But before we get to our Q&A, let's do poll number 2. So we'll go ahead and launch that. Given what you've learned from Timothy Scott here over the past 30 minutes or so, what is your intellectual property posture? At the good end of the scale, you may answer, we've got all of our patentable ideas nicely harvested, prosecuted, and secured. Or maybe you're in good shape, but not perfect shape. We've identified our patent intellectual property, but not yet started the process. Or we know our differentiators, our technological advantages, but we have not yet started patent harvesting, much less prosecution. And then I'm sure this applies to a lot of our audience. We haven't really thought about our intellectual property. And then lastly, identifying IP just doesn't apply to you. So from good to challenging, we've got all of our patents nicely secured. We've identified our intellectual property, but not started the process. We know our differentiators and advantages. We just haven't started the formal harvesting process yet. We haven't really thought through our IP. We know it exists, but haven't taken that first large step. Identifying IP does not apply to us. So we'll give everybody just a few more seconds to see where you fall along the spectrum. All anonymous, of course. We don't share this with anybody. All right, we'll go ahead and close out poll number 2. And then let me just suggest, Tim, and tell me if this makes sense, but to our audience, next steps. You've covered a lot of ground. I know we had a dry run last week. I learned a lot from you then, but you've given me even more food for thought today. So to try to wrap all that together, we would suggest to our audience, think about your medtech solution. What makes it unique that serves as the basis for intellectual property? And Tim, to a point you made a couple of times, think broadly. Engineers, you're an engineer, I'm an engineer, we tend to think narrowly. Think like a salesperson, a marketing person. Think broadly about what makes your solution unique and valuable to the marketplace. And that's a good starting point for patenting your intellectual property. Another point that you made, number 2, don't procrastinate. Get it done yesterday. Review and harvest your patentable ideas as a critical item on your to-do list. Time is of the essence. You touched several times on public disclosure and what qualifies as public disclosure. It could be that private conversation in your audience. If it's not under non-disclosure, that could qualify as a public disclosure. And then kind of outside the strict bounds of intellectual property, let us know if Galen Data can help you now with your cloud connectivity strategy, and perhaps as it relates to medical device intellectual property. The addition of cloud connectivity may give you a couple extra patentable ideas. So we'll suggest that as your next steps. A couple announcements before we get to our Q&A. We just launched a couple months ago now, the Galen Data Medical Device Partner Ecosystem. In your chat window now, our producer is posting the link, or if you go to our website, galendata.com, hit the About drop down, you'll find partners. And what we've put together is upwards of 10 and growing partners, companies that span the entire range of medical device company needs. Design and development, contract manufacturing, regulatory, sensor platforms. You see our featured partner right here, Greenlight Guru. These are companies that we work well with together for clients mutually. We know them, they know us, not just at a business level, but at a personal level. So you would serve yourself well to go to our webpage, our partner ecosystem. And if you think you need help in one of these areas, click on the links and it'll take you to additional information. Excited to announce our March webinar. It'll be Tuesday, March 23rd. We're going to team with Greenlight Guru. It's going to be a joint webinar. Our co-founder and CEO, Chris DuPont, is going to be our subject matter expert. John Spear, the founder of Greenlight Guru, is going to contribute as well. And the topic is going to be medical device post-market surveillance, how integrating electronic QMS and cloud connectivity offers effectiveness and efficiencies in performing post-market surveillance when you launch your product into the commercial marketplace. I will note that the time is a little bit earlier than our typical 1 o'clock Central start time. We're going to start 3 hours earlier. We put to task a Cray microcomputer and did the number crunching and determined that for a global reach, 10 a.m. Central is the best time to start. So we're going to start at that point in time about a month from today. So let's get to our questions. One more time, you can provide your questions in the question window. Let me scroll down here to see what we have. So we've got a lot coming in right now. We'll just go ahead and, Tim, start at the top.
Okay.
Our first question is there a conflict between a device being patentable, as you reviewed today, having unique capabilities, versus identifying an FDA 510K clearance predicate, something with similar capabilities? How do we kind of mix and match and resolve that apparent conflict?
That is a potential problem, but not necessarily. In many instances, if you're pursuing the 510K route, your predicate device may be 20 or 30 years old. So there may be no infringement risk, but you still may be able to get patents on your stuff because you're applying much newer technology to it. So your technology is not on the technology point that got the original device approval, but it's on how you have solved that problem, or maybe even a different aspect of the problem that just didn't even exist before, modern, software and modern capabilities that we have, or the cloud, or something like that. So it can be and one thing. Here's another tip to avoid getting yourself in a problem. Whatever your predicate device is, when you file that information disclosure statement, when you tell the patent office, here's my predicate device, but here's all the prior art that I'm aware of, make sure if there are any patents, or even if it's just user manuals or something like that, whatever you have on that predicate device, make sure that's part of your disclosure, because you don't, even if it's not particularly relevant, you don't want, if you get into litigation, remember I started out as a litigator, you don't want to have to, if you always think with the end game in mind, this might end up being in litigation. So you don't want to have to litigate, even if you're going to win the issue. You don't want to have to spend $250,000 to $500,000 litigating an issue that if you had just provided the information to the examiner would not have arisen. If you're a startup and you're going to be in litigation with larger companies, they're going to try to maximize your costs, and they're going to raise them. Even if they're not particularly winning issues, they can cause you a lot of expense.
All right. Good advice. Good advice. Here's another good question. Topic's very relevant contemporarily. Can the U.S. Emergency Act utilize your patent without paying any compensation? Thinking about COVID tests, etc.
I don't think so. I'm not familiar exactly with the wording of that act, but generally speaking, it might allow the United States government to use it, but usually they're going to you can potentially go after them and file a court in the court of claims or something like that. There are specialized courts for that kind of thing. That usually you can do that. I mean, it's very. I'm not saying it will never happen, but generally speaking, that would arguably even be a taking under the Bill of Rights. I don't think they can. The United States government, even if they pass a statute, can simply infringe your patent rights unless they do it on a global basis.
Okay.
I would
another question.
If they can just use anything they want and just by declaring an emergency.
Another question just came in. Can you elaborate further on your comment about obtaining foreign patents, quote, at manufacturing sites to prevent somebody from infringing?
This is really a strategic issue, and this is why you want to have that patent review committee that I was discussing. So the companies that I was a part of, we had a quarterly meeting. So we would and different technical groups had goals for new invention disclosure. So we would go through all of those, and then we'd also go through, here's everything that's pending, and it's been pending for a year. Our 1-year anniversary is coming up for filing for foreign rights. Where do we want to file? And so the questions were, okay, where are our competitors? What are our biggest markets? Potentially, where do our manufacturers manufacture? So you want to get, if you know all the infringing devices are going to be made in Germany, that's where you got to have a patent, right? Or sometimes they'll be in smaller countries that normally you wouldn't file in, but you might want to do that. Another one that was important is there a port of entry? We used to file patents a lot of times in the Netherlands because there were ports of entry for medical devices. The particular medical device we had, I think, maybe it was Belgium. It seems like it was Antwerp. So, but sometimes it's a port of entry. You can, if you can get a jurisdictional hook there, you can put some real pressure on them. So ultimately that is a business decision, and that's why you want your committee to be fully aware of it, to understand the importance of IP, and to bring their perspective to that, because you want to make the most informed decisions you can. You can't file everywhere, but you need to identify the critical areas.
Tim, the questions are rolling in fast, so let's get to the next one here. We're pushing the top of the hour.
Okay.
How do you advise on patent protection in the market of China at present?
Oh boy.
I thought that was going to be your answer.
You know, a lot of people will do it. The problem is China has waxed and waned over the last 20 years. You know, for the longest time, people just said it's just not worth it. There's such a home field advantage. Then, you know, in the early 2000s, you know, they understood that, so they had some high-profile litigations where foreign companies did do well there. They got substantial verdicts. More recently, it's sort of swung back the other way. It's very difficult to know is the problem, and you know, really, it's going to depend upon and it probably varies by technology area. The best thing, I think, the better practice is to try to get a strong partner in China that might be able to get some advantage of that home field turf. But you've also got to make sure they're not going to just turn around and start making your device and exporting it, you know, without your consent. So you've got to make sure that tie them down from a manufacturing standpoint, and you can sue them contractually in China or somewhere else. And you also, as a last ditch backup, you need to make sure you can potentially get jurisdiction over them if you have to sue your own partner, you know, elsewhere in the world.
The next question is probably the topic for an entire webinar that we should talk about doing sometime in the future, Tim. Question reads, can you provide some further thoughts on the status of software/algorithm patents for startups?
Yeah, you know, I was just dealing with that this week. I got every time the Supreme Court wades in, and it's done it 4 or 5 times, they make it, they kind of mess it up. The thing you need to try to focus on is you can still get software patents, but you try to link it to a whole system. You try to make it not just, quote, software per se. You want to describe as much structure around that as you can. For med devices, that you have a lot of opportunity to do that, because you may have an implantable device, or you may have, you know, a user input device. Obviously you've got processors, but you're trying to do a certain thing, and then you might display it. You consider ultimately wrapping in the final use of what the computational element is spitting out. You know, how are you using it? You know, you might even claim, you know, if it's software for aiding diagnosis, and again, I don't want to spend a lot of time, but there's a definition of software as a medical device.
Yeah.
If it's firmware in a hardware device, it ain't software as a medical device. So we're talking about really apps, things like that. You want to try to potentially wrap in, you know, another device as much as you can. Put as much hardware in that claim as you can, and then also focus when you're in the patent office, you need to focus on, look, I'm not just using generic computing elements, I'm improving the entire process of computing. I'm having a new system that's basically making it a more powerful machine. Even if it's sort of pure software at that point, when you describe what it's doing, oftentimes you can get around that.
All right.
That could be a whole separate hour on
I think so. Next question. I think this is a bullet point on one of your later slides. Please comment on consumables and patents.
Yeah, everybody knows you want to patent the razor and the razor blade, right? So even if your system is, really has very little consumable, if there's any way to get a consumable in, even as a dependent claim, try to do that. And one way I've often tried to do it is in the medical technology space, your consumable you might need to verify that your consumable is in fact a validated, patch, electrode, whatever, because it can be an antitrust violation or a patent misuse to try to exclude completely other people, but it's certainly fair game to test it, to be able to have some testing algorithm. You could patent that algorithm to, the handshake process between the consumable and the non-consumable, and make sure that it is a legitimate consumable that's safe, that's not going to cause a problem, that is compatible with your system, and that has all the necessary features. You might be able to patent, doing a diagnostic routine and saying, hey, this electrode or this consumable can provide these features, but not these features.
Okay.
So consider how every way you can sort of make sure that the system is going to run and be safe and effective for the patient population.
Got time for probably 2 more questions before we wrap this. Can you explain the concept of the FDA Orange Book for drug products, and how does it apply to medical device / drug combination products regarding patent protection? Good question.
Yeah, I don't want to go a lot into that. That's more of a regulatory issue. The Orange Book basically is the list of new drugs, original patent drugs, and then the generics. There's going to be something similar for I forget what it's called, but for med devices. I guess the Orange Book technically is for drugs. There are a lot of ways to there, and there are a lot of. It's a separate topic. There are a lot of really interesting ways for using the regulatory path to extract value or to impose with patents to impose additional burdens. One involves, for example, using a software as a medical device with a drug, partnering with the drug manufacturer, making sure that's in the labeling, because the new generic can then not get approval until after the software patent, which is typically going to be the second patent to expire, is expired. But the key is you got to have the labeling right on that. Again, whole separate topic.
Tim, we've got 30 seconds left, so time for one more question. How does an engineer know that their idea qualifies for a patent?
Well, you try to think when you had to think a little bit differently. When it's not just stuff, you learn in school, it's just the routine stuff I do every day. When you're trying to solve a different problem, or you had to just, you had to struggle with something, or you had some sort of sudden insight, hey, we can do this a totally different way. It doesn't.
Well, you touched on part of the answer. It's a team effort: sales, marketing,
right.
Management.
Yeah,
well, I think we've run out of time, Tim. We need to wrap this now. So thank you today for a very engaging discussion and conversation, and thanks to our audience as well for attending our webinar and for your very insightful questions. I will remind everybody that Galen Data stands ready to help everybody out there with your cloud connectivity needs. Our Galen Cloud platform provides turnkey connectivity for a wide range of medical devices, including software as a medical device, and other digital data resources. It includes access control, onboard analytics, industry-leading security, and is regulatory compliant. We look forward to seeing everyone at a future Galen Data webinar. Please let us know in the meantime if there's anything that we can help you with before then. Thanks again, and goodbye.